All right, let's get right into it. If you're on your way to becoming a barrister, you absolutely have to get your head around the way the federal court thinks. It's not just a set of rules, it's a whole philosophy. And that philosophy is baked into three sections you need to know backwards and forwards: sections 37M, 37N, and 37P. Get these, and you'll get the rhythm of modern federal litigation.
So you might be asking, why do these sections even exist? Well, this quote from the great Justice Alsop really gets to the heart of it. The problem wasn't just that lawsuits were taking too long and costing a fortune. The real crisis was that the delay and the cost were literally eating away at the core of what justice is supposed to be. These rules were created to fight that corrosion.
So here's our game plan. First, we're going to dig into the problem they were trying to solve. Then we'll unpack Section 37M, which is the big picture philosophy. After that, we hit Section 37N, the duty that puts the responsibility right on you. Then Section 37P, which is how the court makes sure you're listening. And finally, we'll pull it all together so you know the mindset you need to walk in with. Okay, Section 1. Let's talk about the problem. And believe me, this isn't some new 21st century issue. It's so old, it actually has a famous literary nickname. That's right, Bleak House. When the government was introducing these very laws, the Attorney General stood up and referenced Charles Dickens' novel about a lawsuit so long and complicated it destroyed the lives of everyone it touched. Now, that wasn't just some fancy literary flourish. It was a massive red flag. It was the government saying, our court system is in a crisis, and this, Part VB, is how we're going to fix it. So how do you fix a bleak house problem? You start with a very clear, very simple guiding principle. And that principle is Section 37M, what everyone calls the overarching purpose. Seriously, think of this as your compass, your North Star for everything you do in the federal court.
Okay, burn this into your brain. Section 37M, subsection 1, lays it all out. The number one goal is the just resolution of disputes. But that single goal is made of two parts that have to be balanced perfectly. Part A, it has to be according to law, and Part B, it has to happen as quickly, inexpensively, and efficiently as possible. One doesn't outweigh the other. They are two sides of the same coin. Now, Section 37M, subsection 2, gets even more specific, breaking that purpose down into 5 key objectives. Let's run through them. A, the just determination of all proceedings. B, efficient use of judicial and administrative resources. We're talking the court's time, money, and staff. C, efficient disposal of the court's entire caseload. D, getting all proceedings done in a timely manner. And finally, E, resolving disputes at a cost that is proportionate to what's actually at stake.
And here's the kicker, the part that makes this whole thing so powerful. It's in Section 37M, subsection 3. This isn't just a nice idea or a friendly guideline. It is a mandatory instruction. It says that every single rule, every practice note, every decision a judge makes must be interpreted and applied in a way that serves that overarching purpose. This one subsection changes the entire game. Okay, let's move on to Section 37N. Because if 37M is the philosophy in the sky, 37N is where it comes crashing down to earth and lands squarely on your shoulders as a personal, professional duty. This is where it gets real for you. Now, Section 37N is clever. It creates two duties that work together. First, look at subsection 1. It puts a duty directly on the party, your client, to run their case in a way that's consistent with the overarching purpose. And then there's subsection 2. That's your duty. You, the lawyer, must not only take your client's duty into account, but you must actively assist your client to comply with it. You're not just a hired gun. You're an officer of the court with a duty to the system. And if you ever think the court isn't taking this seriously, just read this quote from Justice Lee. I mean, wow. He's talking about lawyers who just throw every possible defense at the wall to see what sticks, fighting tooth and nail over everything. He calls it a time warp back to the 1970s that needs to be exploded. That is a judge in 2023 making it absolutely clear that that old way of doing things is a direct breach of Section 37N, and the court is done with it. Which brings us to the consequences, because this duty has very, very sharp teeth. Under Section 37N, subsection 4, when the court is deciding who pays for what, it must consider if someone has failed to follow their duty. But here's the really scary part, subsection 5. If you, the lawyer, breach your duty, the court can order you to pay the costs personally. And let's be crystal clear, a personal costs order means that money comes out of your pocket. You are forbidden from billing your client for it. So that brings us to the last piece of this puzzle, Section 37P. If 37M is the purpose and 37N is your duty, then 37P is the court's toolbox. It gives the judges all the power they need to manage cases and make sure everyone stays in line. Yeah, this is where the court really rolls up its sleeves. It stops being a passive referee and becomes an active manager of the entire litigation process, all to serve that overarching purpose. Just look at the kinds of powers the court has under Section 37P, subsection 3. It's huge. A judge can set tight deadlines, tell you how many witnesses you're allowed to call, limit the number of documents you can use, force you to put your arguments in writing, and even tell you how many pages you're allowed to write. They can even change the official court rules for your specific case if it helps get to a just, quick, and cheap outcome. This is hands-on, proactive management. And what happens if you don't follow those directions? Well, Section 37P, subsection 6, spells it out. The court can literally throw out your entire case. It can strike out your claim or your defense. It can refuse to even look at your evidence. And of course, it can hit you with cost orders, including the much-feared indemnity costs. The message could not be clearer. When the court gives a direction, it is not a suggestion. So let's pull all of this together. What does this all mean for you, an aspiring barrister standing at the beginning of your career? It means you have to adopt a totally modern way of thinking about litigation. This table really says it all. You start with a problem on the left, delay and cost, the bleak house nightmare. The solution starts with the guiding principle in Section 37M, the overarching purpose. That principle then becomes your personal duty under Section 37N, and that duty is enforced with the court's powerful toolbox in Section 37P. See? It's a perfect closed loop designed for one thing, just, efficient justice. At the end of the day, you have to understand that this is about so much more than just memorizing rules. It's about a culture change. Chief Justice Alsop himself called it litigation good faith. It means your job isn't to fight over every comma and delay at every turn. Your job is to cooperate in a reasonable, proportionate search for the real issues that actually need a judge to decide. That is what it means to be a modern advocate. So as you get ready to start your career, you've got a fundamental question to ask yourself. Are you going to be an advocate in that old school 1970s style? Or are you ready to be what the modern federal court demands? A true agent of the overarching purpose? Honestly, how you answer that question will define your entire career at the bar.